this will be my video lecture for today, August 18. No, it's a Thursday. So we continue for our discussion in labor law, or what we call employment law. But before I start, take this down as your assignment number 9. No? Assignment number 9, which you will be putting in your portfolio. No? Assignment number 9 will be, I want you to list down all the constitutional provisions that affect labor. I want you to, the things that I mentioned yesterday, all the constitutional provisions, you have to list that down and then explain to me why each provision is important. Explain how come that this particular provision is important. Okay, that's assignment number 9. And your assignment number 10 will be, I'd like you to discuss or explain in detail what is the fourfold test. The fourfold test to determine the existence of an employer-employee relationship. When you discuss that, you have to be very specific. I mentioned to you yesterday about the 4 elements or requisites for you to determine that an employment or an employer-employee relationship exists, and that will warrant the application of the labor code. Okay, that's assignment number 10. So we move on for today. Again, we are still on employment law or labor code of the Philippines, which is, what is the number again? It's PD 442. I repeat, PD 442, which was promulgated on May 1, 1974, but it became effective or applicable on November 1, 1974, 6 months after its promulgation. That's the effectivity date of the labor code. So it's an old law, but of course this particular law, PD 442, has been amended. There has been several amendments already. Amendments meaning changes. Okay, clear? So today I will be discussing about why are we discussing certain provisions under the labor code. Well, because someday, somehow, when you become a tourism professional, you will be part of a team. It's either you put your own business as whatever business that is. It might be a travel agency, you may be a tour operator, or any industry that has relation to the tourism industry, or you putting up a restaurant. Of course, when you put those businesses, you need employees, or you yourself will be an employee. And being employees, of course, you should know your rights, as employees, or not only employees. If you become an employer, also you should also know your rights and the rights of your employees. Okay, and because of this, there is the need for you to apply certain provisions of the labor code. Someday, somehow, you have a knowledge of employment law or labor law that we call. Today I will be discussing the different classifications of employees, so that you know different classifications of employment or of employees. Employment or employees. So give me one. One is what we call regular employment or regular employee, or otherwise known as a permanent employee. Permanent employee, or employment. So here, when we say regular or permanent employee, this kind of employee is entitled to what we call a security of tenure. The security of tenure. Security of tenure is a principle in labor law which says that an employee or a person who is who has a right to the job cannot be terminated or dismissed without just or authorized causes. You understand? So here, when that employee is already regular or permanent, you cannot just remove him from his post, from his employment, because he is guaranteed by what we call the security of tenure clause, no? Under the labor code. Okay? So remember that. And how does one become a regular employee? Well, after how many months will an employee become a regular or permanent employee? After good service of 6 months. Then he is entitled to what we call the security of tenure. Clear? So far? So you become a regular employee after good service for 6 months or more. Okay, there's another type which we call, and again, when I say you're a regular employee, you cannot just be removed from office or from your work unless it is for a just or authorized causes. Remember this, no? Because someday you might become an employee, or you may have an employee who knows his right, so you cannot just remove him if he is already a regular employee unless for a just or authorized causes. We will be discussing this later on, one by one, no? The second type of employee is what we call what? Casual employee. No? Casual employee. By the way, for permanent or regular employee, these are jobs or employees that are usually necessary and desirable in the company. Usually necessary, meaning kailangan. Usually necessary and desirable in the trade or business of the employer. No? In the case of casual employee, they are not usually necessary or primarily related to the business of the employer. So this casual employee, they are not usually necessary. They are not usually necessary or primarily related to the business, to the primary business of the employer rather. No? Example, say for instance, when your business has something to do with, say for instance, your business has something to do with say for instance, what we call this, when your business is or has something to do with sales of handicrafts, for instance. And usually, if you're involved here, manufacture and sale and sale of handicrafts. Now, of course, who are the workers that are usually necessary in your business? Of course, the workers who are involved in handicrafts, no? Yung mga gumagawa, just like in Pugaro, no? So those are usually necessary because you cannot also sell or you could not also manufacture without these workers. So there are people there whom later on you could consider already as regular employee or regular employment. So this is your business, handicrafts, production of handicrafts, production and sale of handicrafts. How about, say at one instance you hired a promo girl, no, to promote your handicrafts. Is that usually necessary in your line of business? The answer is no, because you can produce handicrafts, you can sell that even without the promo girl. So in that case, if you hire this, no, he could be considered as a casual employee, no? Clear? Because that kind of employment is not usually necessary and primarily related to to your business of production of handicrafts. Clear? And then next would be we have the seasonal employees. No, seasonal employee or employees. No, if you want plural form. No, regular employees. Here, by the term season alone, usually these are employees who are hired or engaged to work during the season only. No, seasonal. No, seasonal during the season. Like, say for instance, Christmas, something like that. No, New Year, holidays, no, or even summer break. No. So once the season is over, of course they are just seasonal. Once the season is over, of course they are no longer part of the company, and they could be removed already because they do not enjoy what we call security of tenure, unlike the regular or permanent employee. Then we also have what we call project employees. Project employees. What are project? Well, because of this, the term project alone will pertain to a situation where employees have been hired or engaged for the purpose of accomplishment of a project. Say for instance, if the project is for the building of a condominium, no? Once the condominium has already been put up, no, or built, then it is automatic that employment is terminated because of the accomplishment of the project or the purpose. Now we also have what we call the term employment or term employees or fixed term. Fixed term employees. But, well, this one also, by virtue of a fixed term, if you have been engaged for, say for instance, for 6 months, then after 6 months, of course, because this is a fixed term employment, you are already automatically terminated, no? Because fixed term, no? Just like in the case of OFWs, usually OFWs will have a 2-year term, so it's a fixed term. So once their contract expires after 2 years, then there is no more job or no more employment to speak of. Clear so far? And now we talk about, so remember that, no? We have the regular, so the one who is protected by the security of tenure principle will be the regular or permanent employee. You cannot just terminate a regular or permanent employee, as I told you, unless for a just or authorized causes. Clear, Ms. Johnny? Unless for a just or authorized causes. And where do we find the just or authorized causes? You find that in Articles 297 to 299 of the Labor Code of the Philippines as amended. No? So if you want to read about the just or authorized causes, you read Articles 297 to 299 of the Labor Code as amended. Let us take a look at some of the examples of just causes, no? Just causes. The just causes will, of course, give you or empower you to terminate an employee because he has done something, no? The first of the just causes would be what we call serious misconduct. Serious misconduct. Well, of course, you have done something wrong in the company and that is considered serious, then the employer may have the right to terminate you based on just causes. Then second would be what we call insubordination. Insubordination. No? Insubordination would mean that you separated yourself or you do not follow the orders or mandate of your boss. No? You have your own way. No? Insubordination, that will also be a ground and falls under what we call just or authorized causes or we also have gross or habitual neglect of duty. Habitual neglect of duty. You are forgetting your duties and responsibilities, and that one is gross or grave, no? Habitual. Then there is also, this one falls also under one of the just causes. Next would be what we call fraud, no? If you have committed something, no? Fraud, also loss of confidence, no? Meaning breach of trust, no? Breach of trust, and other analogous cases. But these analogous cases, when we talk of analogous cases, similar to all this, no? Similar to all this misconduct or just causes. But these analogous cases should be included in the company policy. That's to be written down in the company policy. What are those analogous cases that may also be akin to any of these just causes? Okay, here so far. So if you commit any of this, then the employer may terminate your services even if you are a regular or permanent employee. But of course, there should be what we call due process. No? And I think you already know what due process means. I have explained that already to you. There are two aspects of due process, the substantive aspect and the procedural aspect. Okay, clear? Ms. Johnny so far? Now we move on to what we call authorized causes. Some of the authorized causes I will be discussing now. No? That even if you are a permanent employee, you may be removed from your job because of authorized causes. So here, a just cause is different from what we call authorized causes. No? So the first is installation of labor-saving devices. Installation of labor-saving devices. You just read articles 297 to 299 for you to know the just or authorized causes. Mine is just a brief discussion. Then second would be redundancy. Redundancy would mean there is a duplication of your functions in the company. That's redundancy. Installation of labor-saving devices. Then we also have what we call cessation or closure of business. Cessation of closure of business. So if a company is already suffering from financial instability, of course, it might be better for him, just like Colegio de San Lorenzo, it might be better for that company or that school to close the business already. Cessation or closure of business. Then there's redundancy. What else? There's one more. No? Retrenchment to prevent further losses. Retrenchment to prevent further losses. No? So of course, this one, you retrench, meaning you remove some of your personnel, especially those that are no longer indispensable in your company, so that you could still salvage the company and still exist, no? Instead of closing it down or permanent cessation of business or closure. No? But mind you, this one you cannot invoke or you cannot employ this authorized causes unless you have given a 1 month notice. To whom? To whom are you going to give a 1 month notice before you could do the termination of your employee, permanent employee? Well, of course, you give a notice first to your employee, no? And then, of course, to the DOLE or Department of Labor and Employment. Otherwise, if you dispense with or you fail to make the notice requirement not to the employee or to the dole, then you cannot invoke the authorized causes. Clear now? So in short, what I'm telling you is that a permanent or regular employee may still be dismissed or terminated from his employment for just and authorized causes. Somehow, when you have a permanent employee or you yourself is a permanent employee, then you have the right, no, to a security of tenure. They cannot just remove you unless, of course, for a just or authorized causes, but always with the observance of what we call due process. No? Due process. Remember this. Always with the observance of what we call due process. And this due process, you have to meet both the substantive requirement of due process or substantive aspect of due process and the procedural requirement or what we call the procedural aspect of due process. What is the substantive requirement or substantive? It is there is a law, specific provision of law governing a certain act or a certain situation. Procedural, of course, we talk about the procedure. You going to court, no, or going to a tribunal. Due process would mean, what do we mean by due process? Giving or affording an opportunity for someone to explain his side, no, in layman's terms. Of course, but you have to comply with the substantive and procedural aspect of due process. I think that is all for the employment law or the labor code, because it might be a very long discussion if we will be discussing all the specific provisions of the labor code. This one, remember that when we were in law school, this took us 2 semesters to finish labor or employment law. Okay, that's all for today. Good day.